Criminal Application number 494 of 2026. Neither party disputed the fact that bond terms had been granted in that matter. The divergence between the parties concerned the nature and subject matter of the proceedings in Mavoko, Miscellaneous Criminal Application E494 of 2026, and in particular, whether the present application seeks to detain the respondent to investigate a matter that was subject to those earlier proceedings. The respondent relied upon the proceedings and ruling in Mavoko Miscellaneous Criminal Application number 494 of 2026 in support of its preliminary objection. The notice of motion and ruling in the said matter were referred to and presented from the bar. While the fact that proceedings had taken place and that bond terms had been granted was not disputed, the character and legal consequence of those proceedings remained in contention. There was no dispute that proceedings had taken place in Mavoko Miscellaneous Criminal Application number E494 of 2026, or that bond terms had been granted. The dispute concerned the character and consequence of those proceedings, particularly whether the present application seeks to detain the respondent to investigate a matter that was previously the subject of the proceedings. Faced with these circumstances, there is always an unsettling possibility that the court could issue orders that could be viewed as countermanding the orders and directions issued by a court of concurrent jurisdiction. In the circumstances, this court directed that the bond terms in Mavoko Miscellaneous Criminal Application number E494 of 2026 would subsist pending the determination of the preliminary objection. The court has considered the preliminary objection, the oral submissions by both parties, the material properly placed before it, and the applicable law. The ruling is confined to the preliminary objection. The court makes no determination at this stage on the merits of the application's substantive application for detention. The respondent's preliminary objection. The respondent contends that this court lacks jurisdiction to entertain the present application because it seeks to detain the respondent for purposes of investigating a matter that was previously the subject of Mavoko Miscellaneous Criminal Application 494 of 2026. It is submitted that the respondent had previously been presented before the court in that matter. Custodial orders had been sought in relation to investigations concerning her, and she was ultimately released on bond. The respondent argues that this court cannot, being a court of concurrent jurisdiction, interfere with or circumvent the orders made in that matter. The respondent further invokes the doctrine of res judicata and sub judice and characterizes the present proceedings as an abuse of court process. The applicant's response. The applicant opposed the preliminary objection. Its position is that the proceedings in Mavoko Miscellaneous Criminal Application number E494 of 2026 concerned investigations into forgery of a title, theft of motor vehicles, and malicious damage to property, whereas the present application concerns investigations into the alleged offense of murder. The applicant therefore maintains that the present application raises a distinct investigative subject matter and that this court is properly seized of jurisdiction under Article 49 of the Constitution and Section 35A of the CPC. Analysis and determination. The court raised an issue, and the issue for determination is whether the preliminary objection raises a pure point of law capable of determination without the ascertainment of disputed facts. This issue is framed deliberately. The court is not at this stage determining whether the respondent should be detained for 14 days. This is a question going to the merits of the substantive application and will only arise for determination if necessary. The law applicable. The law on preliminary objections is settled. In the case of Mokisa Biscuits Manufacturing Company Limited versus West End Distributors Limited, 1969, East Africa Law Report 696, Law JA stated that a preliminary objection raises a pure point of law which, if argued as a preliminary point, may dispose the suit. Sir Charles Newbold P. emphasized that it must be argued on the assumption that the facts placed by the other side are correct and cannot properly be raised where facts have been ascertained or where judicial discretion is required. In the case of Oraro versus Banja, 2005, 1 KLR 141, the court cautioned against a preliminary objection being blurred with factual details requiring proof. The Supreme Court reaffirmed the same position, or rather principle, in the case of Aviation and Allied Workers Union, Kenya versus Kenya Railways Limited, and three others, 2015 EKLR. The applicable principle is therefore straightforward. Where determination of an objection requires the court to ascertain, investigate, or resolve disputed facts, the objection ceases to be a pure point of law. And now we go to the issue whether the objection raises a pure point of law. The respondent relies principally on the previous proceedings in Mavoko Miscellaneous Criminal Application number E494 of 2026. There is a pure question of law in the proposition that a court of concurrent jurisdiction cannot sit on appeal over review or otherwise overturn the decision of another court of concurrent jurisdiction. The difficulty, however, lies in determining whether that principle is applicable to the present circumstances. That depends upon the nature, scope, and subject matter of the previous proceedings and their relationship to the present application. The existence of the previous proceedings and the bond terms granted therein are not disputed. What is disputed is whether the present application seeks to detain the respondent for investigation of the same matter that was previously investigated in Mavoko Miscellaneous Criminal Application number E494 of 2026. The applicant states that the earlier investigations concerned forgery of a title, theft of motor vehicles, and malicious damage to property, while the present application concerns murder. The applicant disputes the distinction and relies on the previous proceedings to challenge the jurisdiction of this court. The court cannot resolve that contest merely from the submissions of counsel. To do so would require an examination of what was actually before the court in Mavoko Miscellaneous Criminal Application number E494 of 2026, the investigative scope of the proceedings, the matters now raised in the present application, and the relationship between the two. The court is therefore unable at this stage to accept either position as conclusively established. An advocate cannot tender evidence from the bar. While the court does not doubt the genuineness of the references made by counsel to the previous proceedings, submissions cannot substitute for evidence where the factual character and legal consequence of those proceedings are disputed. Equally, the court cannot take judicial notice of contested matters arising from proceedings which have not been properly placed before it. The question whether the matters now raised anew overlap with the previous investigation or constitute a distinct investigative issue must be established in the proper manner. This is particularly important because the present application refers to matters allegedly arising in Nairobi which falls within the local jurisdiction of this court. That fact alone does not establish that the present application is distinct from the previous investigation. Conversely, the existence of previous proceedings does not, without more, establish that the present application concerns the same matters. Where an application discloses matters which on their face appear to have arisen within the local limits of the court's jurisdiction, the court needs to hear more before conclusively determining that it lacks jurisdiction. Whether those matters are the same as or distinct from or those investigated in Mavoko Miscellaneous Criminal Application number E494 of 2026 is a question of evidence. There is, in the circumstances, insufficient material to warrant bifurcation of the issues raised in the present application from those considered in Mavoko Miscellaneous Criminal Application E494 of 2026. If upon proper examination of evidence, a distinct issue can be isolated from what was previously before the court, that may provide a basis for the present application to proceed in respect to that issue. That determination cannot, however, be made on the preliminary objection alone. I therefore find that the central premise of the respondent's jurisdictional objection involves contested factual matters. It does not, in its present form, constitute a pure point of law. Res judicata and sub judice. The respondent has relied on res judicata and sub judice. Both doctrines require the court to establish the nature and subject matter of the previous proceedings and determine their relationship to the proceedings presently before it. In the present case, that relationship is itself disputed. In particular, the question whether the matter now sought to be investigated was directly or substantially in issue in Mavoko Miscellaneous Criminal Application number E494 of 2026 cannot be answered without examining the evidence relating to the previous proceedings and comparing it with the matters now placed before this court. The same difficulty arises in relation to sub judice. The court must first establish whether the matter presently before it is substantially the same matter previously placed before the court. That is a factual inquiry where, as here, the parties are not in agreement. The court therefore makes no final determination at this stage on the applicability of res judicata or sub judice. Their determination in the circumstances of this case cannot be divorced from the factual inquiry which the preliminary objection seeks to avoid: abuse of court process. The respondent further characterizes the application as an abuse of the process of the court. Whether proceedings constitute an abuse of process depends upon the circumstances in which they are instituted. The court would have to consider, amongst other matters, whether the applicant is seeking detention in respect to the same matter previously investigated, whether there has been a material change in circumstances, and whether the present proceedings are genuinely independent or constitute an attempt to circumvent the earlier orders. Those matters cannot be determined without examining the factual relationship between the two proceedings. The allegation of abuse of process, therefore, does not, in the circumstances of this case, present a pure point of law capable of determination through a preliminary objection. Jurisdiction. The respondent ultimately seeks a finding that this court lacks jurisdiction to entertain the application. Section 36A of the CPC provides a statutory mechanism through which the police may seek an extension of the period within which an arrested person may be held before being charged, subject to the safeguards under Article 49 of the Constitution. The issue before the court is therefore not whether a court has jurisdiction in general terms. The present application is so connected with the proceedings in Mavoko Miscellaneous Criminal Application number A494 of 2026 that examining it would amount to interfering with or circumventing the orders made therein. The question cannot be answered without determining contested factual matters concerning the previous proceedings and the matters now sought to be investigated. In conclusion, the existence of Mavoko Miscellaneous Criminal Application number E494 of 2026 and the bond terms granted bears the character, scope, and consequence of those proceedings, and whether the matter now sought to be investigated is the same matter, an overlapping matter, or a distinct matter. Resolving that question would require the court to ascertain and evaluate evidence. It cannot properly be determined through submissions from the bar, nor can contested matters concerning the previous proceedings be established by judicial. Consequently, insufficient material at this stage to bifurcate the issues raised in the present application from those considered in Mavoko Miscellaneous Criminal Application number 490 is alleged to have arisen in Nairobi requires proper evidentiary consideration. The factual difficulty underlies the respondent's reliance on res judicata. The same factual difficulty underlies the respondent's reliance on res judicata, sub judice, and abuse of process. These issues cannot, in the circumstances of this case, be determined as pure questions of law. I accordingly find that the preliminary objection does not meet the threshold established in Mokisa Biscuit Manufacturing Company Limited versus West End Distributors Limited and subsequent jurisprudence. The preliminary objection is therefore dismissed. Orders accordingly.
Not much obliged. Much obliged.
Yes, Counsel.
Yes, Your Honor, first, thank you for the well-reasoned ruling. We are much obliged. We have an application to make. Your Honor, we have a miscellaneous application, number E3495 of 2026. That is Republic vs. Rose Mbithe Mulwa, alias Rose Mbithe Detain, and Chris Mulwa.
Let me get the number, Counsel. Okay.
Yeah, the number is E3495 of 2026. Republic vs. Rose Mbithe Mulwa, alias Rose Mbithe Detain, and Chris Mulwa. Your Honor, the matter is coming up before your brother, Principal Magistrate Geoffrey Onsarigo, on the 25th, that is tomorrow. Our application is to have this application, number E3856 of 2026.
You said it's coming up tomorrow?
Yes, it's coming up tomorrow, that miscellaneous application. So we are praying, or we are applying to have this miscellaneous application that is before you to be consolidated with the number E3495 of 2026. We intend to make, or rather we intend to canvass this application together with the miscellaneous application before that court.
E3495.
Yes. Therefore, Your Honor, we are praying that this miscellaneous application be placed before Honorable Geoffrey Onsarigo for determination, for hearing and determination, together with E3495 of 2026, which is coming up tomorrow. And I believe Council can attest to that. The matter is coming up tomorrow. I believe he's still the advocate.
Right.
That will be all from our side.
Yes, Mr. Omare.
Thank you, Your Honor. Your Honor, let me deal with the matter before you.
Yes.
Substantively, the matter before you. The court has said the question that we raised before the court needs us to serve the court with the proceedings and with evidence. Then the court can decide.
Yes.
We shall be seeking time to respond and file that evidence for this court to make a determination. The state cannot run away. By now telling you, convey this file to another judicial officer. That will be a third magistrate. All with the same concurrent jurisdictions. The state was aware of the matter before your brother, Honorable Onsarigo. They opted to file an independent miscellaneous application before you. And that is the concept I was telling you of a galloping state. My client has submitted herself to Mavoko. She has submitted herself to this court. The state now want to take her to another court. You know, we object that line of prosecution. Number two, Your Honor, the miscellaneous application before your brother, Honorable Onsarigo, the parties are the respondent's mother and this respondent's brother. They have never appeared in Mavoko. They were arraigned before your brother, Honorable Onsarigo.
where the state was seeking 30 days. Your brother allowed the state 21 days.
They were seeking for. Right.
Custodial. Your brother granted them 21 days expiring tomorrow. In those proceedings,
Yes.
this respondent is an advocate on record for the two. The state simply wants to conflute everything to stop her from representing her clients tomorrow. Your Honor, it is our submission that in your well-reasoned ruling, you have identified what is required. If this file is transferred to another court,
Yes.
is the question about Mavoko going to be in that court? The question before your brother is whether simply the state has finished investigations and whether they have decided to charge the two. It is completely different from the issues the respondent here is raising. Consolidation is when the issues are similar. The transactional documents are similar. In this, the respondent is out on cash bail.
Counsel, let me just hear you again. From the point of consolidation.
Yes, from consolidation,
Yes.
only matters that have similar issues. The transaction that resulted in the offense is one. That is when consolidation is thought about in law. You know, what is before your brother, Honorable Nusari, and I'm an advocate together with the respondent. The state was granted 21 days to do the investigation. We expect the state to come tomorrow with a charge sheet. Or a request to extend because they have not concluded. I can't remember the file number where the alleged killer, the police officer, was detained for 30 days.
Which in which matter particularly? The rest of them, in
There
with
are
regards
two-
to the cash bill.
There are two miscellaneous application files. One before Honorable Nsarigo, where the mother and brother are coming tomorrow. There is another miscellaneous. I'm not sufficiently, the state must be knowing, where there are other people arrested. One being a police officer.
All right.
I don't know it is in which court, but they were granted 30 days. This has two files, Mavoko and before you. So we completely object to that application, that this file be prematurely be transferred before you apply your mind into the evidence that we have. We are ready to file our responses. In less than 3 hours, we'll have filed all the responses that we have through affidavits. And we are ready to argue that question before you today. Therefore, the application to transfer this file from this court is vehemently opposed. My instructions for my client is that she has confidence in this court. If the state has no confidence before this court, let it come out very clearly and say why. Our client is still out on bond. Those bond terms have not been vacated. We are ready, Your Honor, to deal with the state once and for all over this question. I had Martina, if she's around here, or she's having another matter. That's all. She's held up in another court. Thank you.
Prosecution.
Your Honor, I'll be brief. What you have before this court is an application. And I believe the application is the miscellaneous application E3856 of 2026. That is what you have before this court. The preliminary objection that was raised by the defense has been dismissed. The court is functus officio. There is nothing there. What the court has is the miscellaneous application. We are yet to canvass this application. Your Honor, we are only asking for the matter to be taken to Honorable Onsarigo for consolidation and hearing of the application. And our reasons are very simple. If you look at the face of the application, prayer number 2, we were seeking the 14 days so that we can complete investigations on a murder, on a case of murder, which the respondent is a suspect. These are the similar issues that have been raised in the miscellaneous application E3495 of 2026. Therefore, Your Honor, we are merely seeking for direction.
You said these are same issues raised in which application?
In E3495 of 2026. They are seeking for similar orders. There is an ongoing investigation into a murder case. It is the basis of this application. We are only asking that this application be placed before the other, your brother, Honorable Nsarigo, for hearing and determination and further directions. There is no prejudice that will be caused to the respondent. The respondent, as it is, she already has bail in another matter in Mavoko, as you have been told. So there is no prejudice in her going before a different court for hearing and determination of this application, this miscellaneous application that is before you. That is all.
I know I have no right of when the state talks, but Your Honor, the question I'm asking, what is hard with withdrawing this matter? They should withdraw, file a fresh matter before that court. What we are objecting is transfer.
Right.
What we are only objecting is transfer of a matter that has not been heard. You've not even read that application. So as we are only saying, if they feel that they want to remove this matter from this court, let them withdraw that matter, file afresh in that file. That's my prayer.
All right, Counsel, I've heard you, but I have not recorded that, as you know,
Yes,
procedures of law.
Yes, that's what I'm saying.
I will just take 20 minutes, then I will come back with directions.
Much obliged.
All right.
Much obliged. Thank you.